This is Bloomberg Law with June Grasso from Bloomberg Radio.
For the first time, the U.S. Supreme Court has adopted a code of conduct. It's a response to months of pressure after a stream of ethics controversies that have undercut the court's public standing and shown new light on the justices' friendships and financial dealings. The revelations include reports that Justice Clarence Thomas got lavish vacations, private jet flights, and other gifts funded by Republican megadonor Harlan Crow. But the code won't necessarily mean significant changes in how the 9 justices conduct themselves. The rules are mostly a codification of existing principles, and the justices stop short of creating a system for the public to lodge complaints or for an outside review of alleged violations. The rules are mostly a codification of existing rules that apply to the rest of the federal judiciary, but without the type of complaint system that applies to other federal judges. Joining me is an expert on the judiciary, Carl Tobias, a professor at the University of Richmond Law School. Carl, what's your initial reaction to this code of conduct?
Well, I think it pretty much applies the same ethics rules to the Supreme Court with some limited exceptions, and basically adopts 28 U.S.C. 455, which applies to all lower federal court judges, magistrate judges, district judges, appeals court judges.
Is there anything special in there? Like, would anything there tell you if Justice Thomas has to recuse himself in a case involving, let's say, Harlan Crow?
Yes. I mean, I think there are provisions in there if a justice has knowledge of a financial interest of someone like Crow, then I think the justice would need to seriously consider recusing. But that doesn't change, what we've had before. But I do think that's relatively clear from what's there.
Didn't the justices always say that they followed this judicial code?
Yes. But, I think reasonable people could differ about whether they actually did. I think it's valuable in order to be able to say they are subject to it now and have signed on to this. But it will be difficult to enforce in certain situations, I assume, if other people don't know of some kind of conflict. And so it's still going to be dependent substantially on the justices themselves and recognizing potential conflicts and then either deciding to recuse or, caucusing with their colleagues and deciding whether they should or should not.
So there's no enforcement mechanism. Say a group says, I think that Justice Alito shouldn't sit or shouldn't have sat on that tax case where one of the lawyers involved interviewed him for the Wall Street Journal. Is there any mechanism to enforce that?
It doesn't seem like it, though I suppose someone could try to petition the justices on something that they thought was irregular or inappropriate. And always lawyers have been able to suggest recusal, right? And I don't think that changes. Then the justice can respond to that. And they do. And certainly Justice Scalia did on many occasions, and others have too.
Does it seem like this really moves the ball forward? Does it really change things?
Not substantially, no. I don't think so. But we can't really know because we don't know what has gone on internally in the court among the justices. Some of that's just not public.
What do you mean by that? What could have gone on?
Well, any justice could say to the other justice, I think I have a conflict, let's talk about it, or, I can't decide what to do in this situation. And they may have thrashed it out. We just don't know about that.
With this code, it leaves it up to the individual justice, for example, to decide whether to recuse himself or herself?
I think basically, yes. That doesn't preclude the fact that a well-intentioned justice would bring it up with his or her colleagues. And hopefully that would happen. Seek guidance from them, perhaps.
Do you think it was the public pressure or the pressure from Senate Democrats? What do you think it was that got them to finally do this?
Well, I think discretion was the better part of valor. And I think they realized that it wasn't going to calm down until something happened. And so they needed to act. And I think, that is a good thing in some ways because there was going to be a huge subpoena fight, already has been in Judiciary Committee, and I don't know that was going to really help that much. But again, it doesn't have an enforcement mechanism that you suggest, and so we'll have to see how it works in practice. That may be difficult to detect.
Yes, the Supreme Court is not what you'd call a transparent institution. Well, let's turn now to judicial confirmations. And President Joe Biden reached a milestone. Last week, he secured his 150th federal judicial appointment with a record-breaking number of women named to the bench.
Well, the milestone is important of 150, and now actually it's up to 153, and will be hired today after Judge Anna D'Alba of the Eastern District of California is confirmed to the Ninth Circuit. So in that 150 or so, 100 of those appointees are women. Approximately 100 are ethnic minorities, and 50 or so are black appointees. So he's broken all kinds of records in terms of ethnic minority appointments. And what is also very important is experiential diversity. So you're seeing a number of federal public defenders, state public defenders, as well as civil rights attorneys, people who've worked for the ACLU, legal aid lawyers in the mix. And all of that is what Biden pledged to do and has kept his word, and is continuing to do that with new nominees and new appointees.
Confirmations have slowed, haven't they, compared to earlier in his tenure?
A little bit, yes. And part of it, the issue is nominations, because there are not very many vacancies in states represented by 2 senators, and most of them now are in states where at least one senator is a Republican. But there's been some breakthroughs. For example, there were 4 vacancies in Florida, and last week all 4 people were nominated. 3 were women of color and 3 were magistrate judges. And I think they'll easily be confirmed, and hopefully relatively soon. So that's a promising sign. But there are other red states, for example, Texas, there are 7 vacancies there. I think almost all emergencies. And Missouri Eastern District has 3 emergencies and no nominees. And so we'll be looking at those. There are 2 in the Northern District of Indiana, though Indiana senators have been very good about moving 2 people to the appeals courts and filling district vacancies.
Do you think he'll be able to match former President Donald Trump's 234 judicial nominations, especially because it seems like the Democrats' control of the Senate is in jeopardy?
Well, I think so, because if you look at the comparable date in 2019, Trump had confirmed 46 as opposed to Biden's 37 appellate confirmees. But Biden is ahead on district nominees, 116 to 112. And so depending, of course, on the shutdown, if that comes, and what else happens this year and next year, which, of course, is an election year, when it may slow somewhat, we'll see. But I think he's on track and could do that, but needs to have a few more nominees, and the nominees to be in sync with the Judiciary Committee. Chair Durbin has said he would have hearings every 2 weeks the Senate is in session, and of course you have the holidays coming up, but when they come back in January, I think they will have more nominees, and there's still many on the floor. And so I think he is on track to surpass what Trump did, but we'll see what happens.
Coming up next, those gag orders on Donald Trump. This is Bloomberg. I've been talking to Professor Carl Tobias of the University of Richmond Law School about judicial appointments. Carl, we've spoken before about how Republicans and Republican voters have always seemed to be more concerned about judicial appointments and Supreme Court appointments than Democrats. Has that changed in any respect in light of recent Supreme Court decisions and lower court decisions that don't follow precedent?
Well, I think Chair Durbin and the President and all the Democratic members of the Senate Judiciary Committee are painfully aware of that history. And so rules about blue slips for circuit nominees, they've retained the ones that the Republicans used, and to their benefit in terms of confirming people. And Durbin has expressly said in committee publicly that we're not going to have different rules for Democrats and Republicans. So I think Democrats have learned their lesson to the extent that there were different standards, different requirements. And so now I think Democrats are pushing just as aggressively as Republicans did. But of course they're getting pushback from a number of GOP senators too, who are not always in sync with the nominees of the president.
Do you think that Democratic voters are recognizing the importance of the judiciary when they cast their ballots?
I think so. That's certainly what we saw in Virginia, and I'm in the middle of that. And so the abortion issue was, I think, the driver in the Democrats retaining the Senate in Virginia and then also regaining a House majority here. And you saw similar things in, for example, even red states like Ohio with the abortion issue on the ballot, and a number of other states around the country. So I think, yes, and I think going to 2024 with the chaos in the House of Representatives and with the abortion issue and other hot-button issues, that Democrats are doing relatively well, and especially people are cognizant of the judges because of the pushback on overturning Roe versus Wade.
Speaking of judges and being cognizant of the judges, one judge who's been in the news a great deal is the New York trial judge Arthur Engoron, because of the problems he's had with former President Trump in the New York Attorney General's civil fraud trial against him. So already the judge has fined Trump twice for violating a gag order on him making any kind of comments about court staff. How often do you hear about gag orders like that?
Well, not very often, fortunately, in the past, but I think in the short term we're likely to hear about it more. And I think the judges are perfectly within their rights to take measures to protect themselves and protect their staff, because you do not want those court employees, much less jurors or witnesses, to feel that their safety is threatened by litigants in the court. You just can't have that kind of situation.
When Trump was on the stand last week, the judge was just pushed to the limit. He said things like, "Can't you control your client? You can say whatever you want about me, but just answer the question." I mean, he was just uncontrollable. Now, this is a trial where the judge is going to make the decision. But what happens if Trump decides to take the stand in a criminal trial? There'll be a jury in that case, and how does the judge keep him under control?
Well, I think it's difficult, but I think you're right. The New York judge was a model of restraint and pleaded with the lawyers to try to bring their client under control. And so I think that is the best way to proceed. And I think he showed substantial patience in the face of that. And that's what you want a judge to do, is to be restrained, but to keep the process moving along and to protect court personnel, witnesses, jurors in that situation. And that's one reason for the gag orders and then the penalties. Judges have broad discretion to sanction litigants who disobey any kind of order that the judge issues.
I'm wondering, is this a tactic? Because the attorneys have also been very aggressive in that courtroom and very critical of the judge, to the judge's face. So is that a tactic for an appellate issue? But, I mean, what kind of an appellate issue would it be? The judge lost his temper. Is that an appellate issue?
It doesn't seem like it. But the other thing, of course, is that lawyers are officers of the court, and the court can ask them to try to keep conduct appropriate for a courtroom. And they can do that in any number of ways. But I don't think an appellate court is going to have much patience with arguments based on the fact that the judge overreached, especially if it's extreme behavior on the part of the client or of the attorney.
The judge in D.C., Judge Tanya Chutkan, also issued a gag order. None of these gag orders prevent Trump from talking about the judges in the case, but this was to prevent him from talking about the witnesses, the special counsel, and his staff. And that's being criticized as being unconstitutionally vague. The problem is that Donald Trump is running for president, so even in the New York case, the lawyers contended that he could say whatever he wants because he's running for president.
Well, Tanya Jacoby, in your own publication, wrote a piece responding to that and criticizing the view that it was unconstitutionally vague. And she makes a pretty strong argument saying it's absurd on its face. Trump has made bold threats. If you go after me, I'm coming after you. And that kind of language is inappropriate, and a gag order picks up on that. It says that we just can't have that threatening of witnesses or staff or judges.
That injunction in D.C. is going to be litigated perhaps all the way to the Supreme Court. We'll see. Thanks so much, Carl. That's Professor Carl Tobias of the University of Richmond Law School. Coming up next on the Bloomberg Law Show, the issue of reporters' privilege. A judge in D.C. has ordered a reporter to reveal her confidential sources, and the plaintiff has asked for some stiff sanctions. I'm June Grasso, and you're listening to Bloomberg.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
Almost all federal and state courts have found that state and federal constitutions provide a qualified privilege to allow journalists to refuse to reveal the names of their confidential sources and the unpublished information provided by the sources. There is currently a case in D.C. that's testing that privilege. Catherine Herridge is refusing to reveal her source for a series of stories she reported on in 2017 when she was a reporter at Fox News. Joining me is an expert in media law, Jon Epstein, a partner at Hall Estill. So tell us about this case where the reporter is facing the possibility of some serious sanctions.
From time to time, we have situations in the country where the important policies of the free press and the freedom of litigants in order to get discovery clash. And that's what we had in this case. This is a case where a scientist filed a lawsuit against the FBI claiming that the FBI had breached the Federal Privacy Act by disclosing information, and in this case, by disclosing information to a reporter. The scientist then, in the course of the lawsuit, subpoenaed the reporter in order to get information about who actually disclosed the information that she claims was a violation of the act. Importantly, she got the federal judge to order the reporter to sit for a deposition and provide that information. The reporter, Catherine Herridge, who originally had done the story for Fox and is currently a CBS reporter, but the report was done in 2016. Ms. Herridge sat for the deposition and politely declined to provide that information. And so now what the Ms. Chen's counsel has done is filed a motion for sanctions, asking the court to require Ms. Herridge to finally disclose that information. And those sanctions could be in the form of severe monetary penalties or even potentially jail.
Did Chen subpoena the FBI as well?
That's an important question because it's one of the things that goes into whether or not the information should be disclosed. It's what information has she sought in the litigation? Has she done whatever she could in order to get alternative sources? And so I don't know to what extent she has actually gone to get that information from the FBI, but the judge has determined that she has done enough to seek information from alternative sources in order to require this reporter to disclose the information.
Tell us about the reporter's privilege in general.
So the reporter's privilege is different with respect to each state except for one has its own reporter's privilege. And then the federal law has its own different set of reporter's privileges. So that it becomes a little bit confusing as to in which jurisdiction you find it in. But most of the reporter's privileges provide it's a qualified privilege, which means that the reporter may be forced to disclose confidential source information or unpublished information if certain things apply, one of which is, does the information go to the heart of the matter? is it absolutely necessary for the litigant to have? The other is, has the litigant tried to get the information from alternative sources? And, of course, is that information available from alternative sources? Then the court would then have to balance the interests between whether or not the litigant should be able to get the information, or whether or not, even if there is no alternative source, whether the reporter should be able to withhold that information because the policy reasons behind the reporter's privilege.
So in this case, the judge then did what he was supposed to do. He balanced the interests, and in his opinion, the interest weighed in favor of the disclosure?
That's what he said, and that's what he said initially. So initially what happened was the subpoena was issued, and immediately the reporter said, no, I'm not going to comply with the subpoena. They went, and the judge ordered her to at least sit for the deposition. She sat for the deposition, and then when the questions were asked about who her sources were, she declined to provide that information. And so then the litigant, the scientist, Chen, and her counsel had to go back to the judge and say, okay, she's now declined. Now we want you to issue sanctions. So the judge has not yet issued any sanctions yet. That's still pending. But that is likely to happen. There's going to be some sanctions that will happen. The question is, what are those sanctions? So the judge believes that based on what he heard, that the balancing required disclosure. Of course, that was met with some serious backlash from media advocates and free speech and free press advocates. And the reason is because even if there were no alternative sources, you've got a situation where if this reporter is sanctioned, whether it's severe monetary sanctions or prison, you're going to put this reporter and the next reporter on the next important case in a position to whether they have to choose between whether to sit in jail and wait for something to happen or pay a high fine, or to basically burn the source. The reporter had agreed to give confidentiality to the source so that the source would come forward. And so that choice will have to be made. If that choice is made, and for instance, and the source is disclosed, then what happens in the next case when the next reporter seeks to get information from a source? That source may not be willing to give it if they're concerned that the confidentiality will be breached. And so these are, on face you would think, okay, this is a litigant that wants to get information. They should be entitled to that information so they can litigate the case. But it has ramifications, and the ramifications are it may be that if future witnesses or whistleblowers are afraid to come forward, then important information will not reach the public.
Are there any circumstances in which the judge would be correct in ordering a reporter to reveal his or her sources?
There was an important case years ago called the Brandsburg case, which a lot of this comes from, at least with respect to federal jurisdiction. And in Brandsburg, a third party or a witness was subpoenaed by the government to appear at a grand jury proceeding and to testify. And the reporter, that was a reporter, and the reporter fought that, and the United States Supreme Court determined that no, under those circumstances in that case, the reporter was required to testify at the grand jury. And so a lot of times that comes into place when the reporter is actually a witness to a particular crime. In that case, courts sometimes say, well, a journalist should be treated just like any other person. And if you're a witness to a crime, you should have to testify before the grand jury. Where a lot of these cases come in is not necessarily when the journalist is a witness to the crime, but when the journalist is actually, as a private citizen, but it's when the journalist is actually serving as a reporter and getting information about a crime that has already happened. Then the question is, should that journalist have to come forward and testify about what that journalist learned from its sources? And I've explained why, I think that it's really important to be able to protect your sources and your unpublished information because, it could lock down. There's been so many important stories over the years that have only been told because the witnesses or the sources came forward and required confidentiality. Had that confidentiality not been promised and protected, then those witnesses wouldn't have come forward and the public would never have learned about these important things.
Where does the importance of the story weigh in here?
The more important the story is, that's one more argument in favor of not disclosing. But I would argue also that even in what you or I might determine to be a lesser important story, if it's important to somebody. It's important to the confidential source. It's important to the people that are involved in that particular issue. And even if it might not be important to the rest of the country, it's still a confidentiality that was promised. And so if that confidentiality is breached in that what you're thinking of as the lesser important story, it still could impact the next very important story if that witness in the very important story is concerned that his identity is going to be disclosed also.
So in this case, Chen is alleging that the federal authorities improperly leaked information about her, violating the Privacy Act. So if she doesn't get that information from the person it was leaked to, then I suppose her case is dead.
Well, I don't know if it's dead. I certainly don't know all the ins and outs of everything having to do with her particular case. But the fact of the matter is there was information that was published in those 2017 stories. So maybe if she can't find out who, in fact, disclosed it, she at least has the information that, in fact, information was disclosed. And whether or not it kills her case that it was a particular person at the FBI that disclosed it, or whether it was just somebody at the FBI that disclosed it, she still might be able to proceed forward. And also, we don't know. I mean, there may be other ways for her to get the information of who specifically disclosed it, by going through the FBI or potentially other sources that we just aren't aware of.
Are cases like this over reporters' privilege regularly litigated? Have we not been hearing that much about them because, investigative journalism is not what it used to be?
Yeah, I think some of that, but yes, definitely in our practice, we are often asked to go into, and when I say often, I mean 2 or 3 times a year, are often asked to go in and protect the rights of the reporter or the media outlet from having to disclose either confidential sources or unpublished information. So it happens. It does happen regularly, but it doesn't oftentimes get in the news as much as this particular case, unless you've got a pretty high-profile litigant or high-profile reporter, or a situation where a reporter is actually doing some time. You might remember several years ago, New York Times reporter Judith Miller had a confidential source case, and she refused to disclose the identity, and she actually sat in jail for 85 days. So, it's interesting. I don't know specifically what the strategies are of Chen or even of the judge in where he sees this case going. But he did issue an order last week or so, and he said, now that the contempt proceedings are teed up, one of 2 outcomes appear likely. Either Herridge will be held in contempt in the near future and can immediately appeal that order, or, as sometimes occurs in these cases, the sources may release Herridge from the privilege rather than watch her undergo the consequences of the contempt. So that happens sometimes, where you've got a source who sees now that the reporter is willing to go to jail for that source, and then the source comes forward and says, no, I don't need you going to jail for me. I'll come forward and I'll identify myself. So now you're not being held in contempt for failing to disclose. That happens. My concern about situations like that, while I appreciate it, my concern about that is I think it still might impact the future case where a future confidential source is concerned about whether or not they're going to disclose something based, on the, prospect that the reporter might be jailed and they might have to come and identify themselves. So I still think the issue still is important.
We assume she's going to appeal this. Where would the appeal go? Is this a D.C. case? Absolutely. And we assume she's going to appeal this. That would be to the D.C. Circuit Court of Appeals. So where do the sanctions stand? The
Chen lawyers have filed for sanctions, and now the judge is going to have to consider that and determine if sanctions are going to be awarded, which is probably likely, and then if they are awarded, what are those sanctions? The Chen lawyers have asked for pretty severe sanctions because they believe that Fox, because that's where Catherine Herridge was when the stories came out, they think that Fox is funding and would basically put up any money if there was a monetary deal. And so they don't believe that would actually be any pressure on her to disclose the information. And they want individual sanctions on her also. We don't know what those sanctions would be. It could be more severe personal monetary sanctions where she'd have to pay them herself, or possibly jail or something else. But it'll be pretty strong. And then once that happens, she'll have the right to appeal, and I'm sure she'll appeal immediately. And then there's also questions about if she is sanctioned, would the judge then stay those sanctions pending the appeal? And I don't know the answer. I don't know what the judge will do in this particular case, but my guess is that the appellate court would get to this issue rather quickly.
Is there anything happening in Congress?
Almost every state has a journalist privilege statute. Federal law does not have a statute on the newsman's privilege. And so from time to time, there's bipartisan efforts taken in order to try to get a newsman's privilege act codified. And so lately, there's been something called the Press Act. That is where certain legislators on both sides of the aisle are trying to get a newsman's privilege codified for federal purposes. As of now, that has not passed. My personal concern is it might not be politically expedient for some legislators to vote for it, and so I'm concerned about that.
Thanks for being on the show, John. That's Jon Epstein, a partner at Hall Estill. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.